Okay, let's talk about Derek Chauvin because this trial could be a first historically. We all know Amadou Diallo, or maybe you don't. He was a gentleman who was in his 20s who was killed by four on duty plainclothes police officers. He was shot 41 times in his own foyer to his apartment in the Bronx. The police were indicted and they were acquitted. We all know Rodney King, which those of us who remember answering telephones back before we knew who was on the other line, knew that the fact that there was video evidence back then of the actual beating, everybody was certain for sure that there would be a conviction in that case, and there was not. There was an acquittal. Some people have even speculated that the OJ verdict was a direct response to that acquittal. That's long before my time. I'm not going to comment on that. And then most recently there was Breonna Taylor, where the police weren't even indicted. The only thing that happened was one officer was held to have violated the agency standards because he fired into the window without having an actual target in sight. And the district attorney, who was African American in that case, was actually accused by grand jury members on a 2020 special that aired in 2020 called Say Her Name, of hiding evidence from the grand jury to protect the police officers. The grand jurors went on, their faces were blurred because grand jury testimony is secret and who's on the grand jury is secret. But they actually went on TV and made a complaint that the state's attorney hid evidence to prevent them from handing down indictments. So there's just never been a case where they've successfully convicted an officer. So what makes this one different? Well, unfortunately, in order to go over that, I'm going to have to cover some basic legal stuff first. First, there's what he's charged with. I want to make sure I get this right. He's charged with second-degree murder, which if anyone wants to look it up for the exact language, it's Minnesota Statute 609.19 sub 2 sub 1. Second-degree murder in Minnesota is actually the same thing as it used to be first-degree murder and a death penalty bounce here in Connecticut when we had the death penalty, but it's what's called felony murder. Now, felony murder is an interesting legal concept. Basically, if while you're in the course of committing a felony, someone dies, and it's because of that felony, that you committing that felony causes the death. So let's say you're robbing a bank, and a police officer accidentally lets a bullet fly and it hits a bank teller. You're on the hook for felony murder but for the felony, and I'll get into that, but that caused that person to get killed. So that charge is effectively a 40-year sentence tops, but they have to prove that there was excessive force and that excessive force amounted to felony assault, that he was effectively assaulting George Floyd while he was kneeling on his neck because he had exceeded the force guidelines and it amounted to an actual assault. That's the highest charge. The middle charge is third-degree murder, which is Minnesota General Statute 609195A. Their statute numbering makes no sense to me. This is essentially you cause the death of someone through without intent to kill, but while, quote, perpetrating an act inherently dangerous to others and evincing a depraved mind without regard for human life, you cause a death. You'll notice again the word cause shows up, but that's just a fancy legal way of saying reckless. You were behaving recklessly and you caused someone's death. So again, kneeling on his neck would be excessive force, and it would be reckless in that another way to define recklessness is he knowingly disregarded a risk to George Floyd, that he knew kneeling on him would be a risk of death. He disregarded that risk, knelt on him anyways, and it killed him. That would make him guilty of second-degree murder. Then we have third-degree manslaughter. Second-degree murder, 25 years in jail. Tops. Second-degree manslaughter, now we slide down to the lowest charge, again, causes death. This one is by a negligence standard. This one is Minnesota Statute 609.205. Again, numbering doesn't make any sense. But causing death of another by culpable negligence, whereby creates an unreasonable risk and consciously takes chances of causing death or great bodily harm. In this case, the excessive force would have to amount to negligence, and it would have to be conscious negligence. I'm supposing they put that language in there so that people don't get charged with second-degree manslaughter for like car accidents, like regular negligence, because it would be dangerously close if they didn't. So what makes this so different? Well, first of all, I'd like to point out that if you're a law student or anyone who's studying the law, do not use this trial as an example of a proper way to examine or call witnesses, because it has been, from my perspective as a trial attorney, a train wreck by both sides. They have been asking objectionable questions on both ends throughout the entire trial process. The state has been leading on direct, and the defense hasn't been objecting. The defense could have led during cross-examination of state witnesses, but are now recalling those witnesses on their case in chief, where they have to ask them open-ended questions and are giving the state the opportunity to cross-examine their own witnesses that they called, which the difference between cross-examination and direct examination is the way you phrase a question. When it's your own witness and it's not someone who's hostile to you, you have to ask open-ended questions. I'll start with cross-examination. Cross-examination is when the witness is not on your side. But if you call them, you can't cross them. But you can ask leading questions. A leading question would be something like, you're about to click off this video. If you notice, that's not actually a question. That's a statement. You're about to click off this video. You do the actual testifying as an attorney when you're cross-examining a hostile witness. On direct examination, it's the exact opposite. You can't suggest the answer to the question in the question itself. That's what it's defined as, but really I just say it's a statement with a question mark at the end. It would be like, how do you like the video so far? You could see how it's much easier to get where you want to go when you can lead. And they've been just letting it be a free-for-all during this entire trial. I can't even make sense of it. But what sets this trial apart, obviously, you notice from all three statutes, the state needs to prove causation. That in all three instances of what they're charged with, and essentially what the state has done is they've given the jury, depending on how sympathetic, because they didn't know how sympathetic Chauvin would be when it started, the jury is to him a choice of, basically he did it, it was an assault, which basically rises to the level of intentional conduct, and caused his death in the felony murder, 40 years in jail, down to reckless. It was a reckless disregard. He knew it was dangerous. He did it anyways, and he killed him. 25 years in jail. Or he was just negligent. You know, negligence is the reasonable person standard. You'll hear it throughout the entire trial. You've probably heard it on the news. The jurors are supposed to be reasonable people. It's, was there a duty that you owed somebody? Did you breach it? And did it cause someone a harm? That's the definition of negligence. Now, there's two types of causation. There's legal causation, which is what we call but-for causation. That would be like, but for Hitler's parents giving birth to him, there would have been no Holocaust. The problem with that is it's so ginormous that you can basically say anything. You know, the whole butterfly flaps his wings, causes a tsunami. Basically anything can be linked in through but-for causation. So on top of that, we have what's called proximate cause, which is reasonably foreseeable. Although Minnesota actually uses the exact same definition that Connecticut uses for proximate cause, which is the substantial factor test. So basically what the state is trying to prove in the Chauvin trial is that him kneeling on George Floyd's neck was a substantial factor in the death of George Floyd. If they can prove that, they've got him on at least the bottom count. And it looks like they've done that. From my watching of the testimony, aside from the just absolutely horrific manner in which they've been questioning everyone, they've, despite the defense's best efforts, because the defense has been doing everything they can to bust up causation. That's why they're doing such a hard job trying to prove that there was drugs that caused his heart to stop, that it was his heart condition. They're going after causation because causation is their only thing that they can use to beat all three charges. So that's why the defense attorney's strategy is to go after that. It's what I would go after if I was on it. Personally, I think I would do a better job than this guy's doing, but his strategy outside of that simple aspect has been pretty terrible. But the state seems to have debunked it pretty well. There was the witness who testified that measured his breathing, his respiratory rate, and counted out how many breaths he had, and counted out 8 during the 17-second period, and said that's regular respiration, which if you have any experience with drug addicts or narcotics addicts or any knowledge about narcotics, you know that narcotics depresses your respiration. So if he was experiencing some sort of fentanyl toxicity, his breathing would have been slowed, and they effectively proved right in front of the jury that his breathing wasn't slowed. And they also had another witness come in and just directly testify that there was no evidence in the toxicology report because there are DUIs in Minnesota that had higher fentanyl counts than George Floyd did. And as for the methamphetamine, that was like lower than any of the DUIs. It was in like the lowest 10%, which I thought was a very creative move by the state. Another thing the state did that they've never done before is they hired an outside lawyer, a private attorney, to come in and work pro bono to do the case, which I thought was ingenious because they don't have that relationship between the state's attorney's office and the police, like you saw in Breonna Taylor, where the state's attorney was accused of trying to protect the police. And that's the other thing about this case that's just really been the nail in the coffin for Chauvin. And as an attorney, he's innocent until proven guilty, but I don't think the defense is going to have a leg to stand on. I didn't make a video until the state had rested, and I at least saw the defense begin to put on their case. They're claiming that they may be arrested by as early as today or tomorrow. So I feel confident in saying, unless I'm missing something, I find it very difficult that they could even get a single hung juror in this case. There hasn't been any evidence put up by the defense that really shoots a hole in anything. And let's be honest, the videos are just horrifying. I mean, it's just heartbreaking. So I think that and the first time in history, the blue wall is collapsed. You have the chief of police coming in and testifying against Chauvin. You have the most senior member of the force coming in, the guy who's been on the police force the longest, saying he doesn't even want to be in the same room with him. The person who does the training at the reasonable force training for the cadets came in and basically said this violated the standards for reasonable force. I mean, and the fact that he kept kneeling on his neck after he was dead and there was somebody telling him, check his pulse, check his pulse, check his pulse. I mean, it's really bad. If I was in court and I was defending Chauvin on this, I mean, God bless his attorney. He's doing the best he can with what he's got. But given the evidence that the state was able to cobble together here and the amount of stuff that they've got and the fact they've got the police on their side, I think you're about to witness what this country's been waiting for. And with this past summer, with all the Black Lives Matter protests and everything else, I mean, let's be honest, it's just in the air. The time just seems to be right. He's going to get hit. And it's just a question of which one they're going to hit him with. I mean, you'll know how well the state did and how successful they were in their case by which count they pick. Do they pick the top count and send him for 40 years and say that was an assault, that was intentional, you did that on purpose? Do they say you were reckless, which is the equivalent of drunk driving, killing somebody while they're drunk driving? That's reckless. You'll go to jail for that. That without question. That's a murder. Well, that manslaughter. But I mean, according to this statute, it's murder in Minnesota. But reckless conduct would be driving drunk, killing somebody with the car. You knew it was unreasonable to drive drunk. You knew it was a risk that you'd hit somebody, do serious damage, and then you did. Disregarding a known risk, that's recklessness. Do they hit him with that? Or do they go for the absolute lowest, which is you didn't behave reasonably. A reasonable person would have gotten off of him and rolled him over, especially when there were people screaming at you, he's not breathing, there's no pulse. So, in my opinion as an attorney, having watched this very closely, and again, I'm just appalled at the actual amount of objectionable material that's gone through, and the questioning that they've done has just been atrocious. And the defense attorney recalling state witnesses in his case in chief, giving the state the right to cross the witness and ask leading questions. Not that it mattered, because the state was asking leading questions when they had those witnesses up on direct, which is what was driving me crazy. But mark my words, I'd bet my whole 10 subscribers or whatever I have on this channel on the fact that Derek Chauvin's gonna get convicted. It's done. I'd be shocked. Just like I was made my Gates videos, and now it's come out that there's text messages telling people to lawyer up and stuff like that. I know I promised I wouldn't make another Gates video, and as tempted as I've been to do it, I haven't made one yet. I'm waiting for him to actually get charged, but he's getting indicted. There's no question about that. Again, innocent till proven guilty, but there's no way that he's not getting indicted for something given the stuff that's come out since I made my last video. But that's all I have to say on the Chauvin matter. Just so everybody knows, if you're a fan, if you're an AMC or GME holder like myself, I was listening to Matt Kors this afternoon while I was at work, as I do every day to monitor my stock. And apparently Trey's interview for the project, the not Netflix documentary, the other one that they're making, is being released on his Trey's Trades channel tonight, his interview. So a shout out to Trey, and to anybody watching this, keep an eye out later tonight. His interview for that documentary is going to be released tonight. Other than that, I thank everybody, anyone who actually stayed through and watched this till the end. Appreciate it. I'm not going to ask you to subscribe or ring the bell or any of that stuff or hit the like button, because it's just not my style. And good luck to everybody, but you mark my words, if I'm wrong, come back, comment on the video in the form of an objection, and call me an idiot. Say I'm a terrible attorney. Say I don't know what I'm talking about. But 16 years of trial experience, and I haven't seen the jury because they won't put them on TV, so I haven't been able to see the jurors' faces, but all I've heard is what they say on the news about when they're taking notes and when they're crying. They've hit the emotional, they've hit the technical, they've hit it, the state's hit every base. If I was defending this case, I would be begging the state for a plea offer, and I would be shoving it down Chauvin's throat. I would tell him, you need to take a plea, you need to work out a deal, because you are about to get your bell rung. So if I'm wrong, feel free to come on here and crucify me in the comments, but I don't think I'm wrong. All right. I've wasted enough of everyone's time. Thanks for clicking, thanks for watching, thanks for staying if you did. Appreciate it.